New tonight, Hennepin County Attorney is rolling out a new policy to make sure criminal trials are fair, and it focuses on the credibility of any officer who testifies. This is in pursuit of new national guidelines on full disclosure. John Croman walks us through the new standards.
We know in trial situations, the defense is allowed to question the reliability of an officer's testimony based on that officer's past records. The new standards, aimed at making sure trials are fair, require prosecutors to disclose to the defense team as much as they can about the officer's disciplinary records or problems with previous testimony. Now, County Attorney Mary Mariardi today said that she's been working with local law enforcement agencies to come up with a plan that meets the new rules known as the Brady-Giglio disclosure. The name comes from two U.S. Supreme Court rulings dealing with officer conduct that would allow the defense to cast doubt on their testimony. In the past, there have been cases that were thrown out of court because the defense wasn't told everything they should have been told about the officers that were testifying at trial.
There was some confusion here because the previous administration, when asked, said that it did not have a Brady list when it in fact did. It had a computer database of instances that should be disclosed.
Moriarty also said the officer's past discipline doesn't necessarily disqualify him or her as a witness because the prosecution can always argue that that's not relevant to the current case at hand. But the best of all worlds, those arguments can be made before the case goes to trial rather than having the defense lawyers confront the officer in open court. We'll have a lot more on this coming up at 6:30 on Breaking the News. Back to you.
All right. Thank you, John.